Good afternoon, ladies and gentlemen. Please be seated. All right, we're here on defendant Flagstone and City of Miami's motion to dismiss a plaintiff's verified complaint, as well as a request for a postponement by the plaintiff. Parties, please state your appearances for the record.
Your Honor, I'm Sam Duggan on behalf of the plaintiffs.
Welcome.
Good afternoon, Your Honor. Forrest Andrews on behalf of the City of Miami, and also present are the City Attorney for the City of Miami, Victoria Mendez, and Assistant City Attorney Stephanie Panoff, and Robin Jones-Jackson.
Good afternoon.
Good afternoon, Your Honor. I'm Alan Diamond, and with me is Tim Kalaya with the Greenberg Short Firm, together with our co-counsel Jeffrey Bass, from Shubin Bass, General Counsel for Flagship, Natalie Guillaume.
All right, good afternoon. Again, I want to welcome everybody. I know plaintiffs late yesterday filed a motion for postponement. I thought we would reserve about 5 minutes to address that first.
Thank you, Your Honor. May I quote?
You may.
This is an additional document that I supplied the other side with before the hearing. This is the deposition of the city's representative, Aldo Bustamante, who was required by Judge Trawick in the other case to talk about the city's compliance with Mr. Herbert's public records requests. And as I indicated in the letter yesterday, what the city produced was a permit that was ostensibly issued by the Public Works Department on August 15, 2014 for the Mega Yacht Marina portion of this development. Now, one of the central questions in this complaint, count 5, is whether the defendants should be allowed to proceed with this entire project because the developer failed to meet the June 2nd deadline. That was a very hot topic at the City Commission meeting on May 8th, whether or not the city would even allow them to go forward. But one voted no. Two commissioners said, well, the legal department told us we have to let them get to June 2nd, so we'll let them get to June 2nd. Now, and then on August 15th, Mr. Herberts had to sue the city to get records they were withholding for 3.5 months. That's not disputed. And Judge Trawick ordered them to produce them on a rolling basis and to allow plaintiffs to take the depositions of the witnesses to ensure that all of the documents had been produced. So we took Mr. Bustamante's deposition in November 2014. He testified that every single document that was responsive to Mr. Herbert's request under Judge Trawick's order had been produced. Now, this supposed permit dated August 15, 2004 was never previously produced. Now, this is what's called a smoking gun in litigation parlance, because this is something the city hid from Mr. Herberts, hid from the order to produce, and hid from the public because it demonstrates that they went out after the June 2nd deadline to get this permit. And it's consistent with the pattern of illegalities ranging from the violations of the public records law, forcing Herberts to go to court 3 separate times to get those records, and the suppression of information that would show that they're violating the charter by allowing this project to continue to have life after 10 years of failure. The appraisals that you read about, the traffic studies, and all of this information about the commencement of construction. Because this document should have been produced in their electronic search, because the search terms include Flagstone, which is in the emails that I produced yesterday, somebody didn't produce that permit. Somebody didn't produce those emails showing that they were scrambling to get that permit in the middle of August of 2014. That not only calls into question the validity and the integrity of the city's process dealing with that issue, but everything, because the appraisals, the traffic studies, these are all part and parcel of the suppression of information about the impact of this project on my clients and the violation of the charter that the city manipulated on behalf of this private developer. That's what this case is all about, that the charter was violated and that the impact on my clients and their neighbors was suppressed by the city in the process of trying to breathe oxygen into this project, which had gone nowhere for 10 years. So this discovery calls into question everything. We request that we get to go back to now Judge Rabul, who's the new judge on the case, and make sure that the city has produced everything so that the Third Amendment complaint can be current, up to date, with every possible shenanigan that the city has undertaken in the process of violating its charter, putting my clients in harm's way with all of all of the, special injuries we have alleged in the Third Amendment complaint.
All right, we're here today on a motion to dismiss where the sole legal issue before the court is standing. Nothing that Mr. Dublin has said would impact the court's ability to rule on that issue. As he said, as closed up with, he can go before Judge Rebel, and if he believes he has an argument or an issue there, he can go and argue that there in a separate case which has no bearing on the issue here today. The issue is whether or not the claims have standing. Either they do or they don't, and the continuance is not going to change that fact. The facts haven't changed, the law certainly hasn't changed. This is just an attempt by the plaintiffs to try to delay this proceeding much further than, they've tried to delay it already, since January when we first filed this motion to dismiss, and this is just another attempt to do that. This issue has nothing to do with the issue we're here on today, and the city and Flagstone are prepared to proceed today.
You will adopt his argument.
All right, let me start by saying that I'm not going to preclude you from raising arguments, but my thoughts are on this matter that everyone's prepared a lot, including myself. I've taken a lot of time reading all of the voluminous documentation, and I thank you for briefing the issues so well for me this week. So rather than waste this hour where we have everyone who's taking time out of their day to come, my thought process was that why don't we proceed to arguments based on what the pleadings are before me today. Being that these issues are so important, I'm going to be taking them under advisement anyway and giving you a written order at the end. Rather than giving you my written order in the next couple of days, perhaps I would afford you 15 days additional time to add or brief me on anything specific only to the new documentation that was provided to you, only as to those issues, not what's been briefed up until today within the next 15 business days. If you need short argument on those matters or anything else you plead, I'll be glad to forward that to you. Does that work for everyone?
Thank you, Your Honor.
Thank you.
All right, so why don't we go ahead, since it's defendant's motion, and they can begin.
Good morning. Good afternoon, Your Honor. Alan Diamond, representing Flagstone. Your Honor, we are here today on motions of the city and Flagstone to dismiss the complaint. I'm going to speak first on behalf of both the city and Flagstone. Ms. Forrest will hand over the rebuttal. To the extent that the court has questions, we will both be available to the court. Your Honor, we're here today on what amounts to nothing more than a motion for rehearing. This court dismissed the plaintiff's claims against Flagstone on December 12th, concluding that plaintiffs lack standing to maintain this action. Since December 12th, there have been no new law, no new facts alleged or suggested with regard to standing, and no change in the necessity for this court to follow the clear holdings of the Florida Supreme Court. The court's holding in December was based on the deeply rooted public policy principles that a citizen may not challenge governmental action unless that citizen has alleged that he or she has suffered a special injury that is different from the injuries suffered by the public at large. The plaintiff argued at the prior hearing that the city's agreement with Flagstone violated the City of Miami's charter and was therefore void, and not subject to the taxpayer standing doctrine. This is the same argument that was and remains expressly rejected by the Supreme Court of Florida in 1985 on a certified question from the 4th District Court of Appeal. In two cases, Cordes and Bull. Each of those cases are found in tabs within our binder, A17 and A5. We have elected not to burden the court with citations throughout this proceeding, and we have, in fact, included an appendix which distinguishes each of the plaintiff's cases. So we want to talk about the overall big picture here, Your Honor. So it'll be very clear when you review those cases, as you've indicated you intend to do, and read them memorandum that you'll understand the context of our argument. As a general rule, a party is not permitted to challenge an action such as a contract that they are not parties to. This is the basic law of standing, Standing 101. This rule applies to private contracts and to government contracts alike. In the context of governmental action, citizens are deemed not to have sufficient standing to challenge any action taken by their local representative government unless they have a special injury or a constitutional challenge. Every member of the public may be impacted indirectly or receive some benefit from every action of their local government. But that does not mean that every member of the public may challenge every single governmental act with which he or she disagrees. An exception to the rule is the taxpayer standing exception. Florida courts permit citizens who are not parties to a contract and not directly involved in certain governmental action to challenge governmental action if they have suffered a special injury different from that suffered by all other citizens. This rule is known as the Rickman Rule, and it flows from a Supreme Court decision in 1917, cited as Rickman tab A19. The public policy behind this rule is that government should be allowed to conduct its business without having to defend numerous lawsuits from citizens who simply do not agree with the government's decision. Or, like here, citizens who disagree with the overwhelming majority of the citizens of the city of Miami. Only those people who suffer direct, distinct, special injury may challenge a governmental action. The 1985 cases that the Supreme Court of Florida issued reaffirmed the taxpayer standing document. They said very specifically that the Supreme Court, on the first page of its holding, we quash the district court's holding that a taxpayer has standing to challenge the expenditure of public funds by simply alleging that such expenditure will increase her tax burden. Rather, we continue to adhere to precedent and hold that absent a constitutional challenge, a taxpayer must allege special injury distinct from other taxpayers in the taxing district to bring suit. The court specifically said it agreed with the third district court's ruling in Paul v. Blake, where it noted this: we recognize that all these standing rules are based on highly debatable policy choices, but they represent, in our view, a reasonable effort to guarantee that the state and counties lawfully exercise their taxing and spending authority without unduly hampering the normal operations of a representative democratic government. We adhere to these rules today because they are based on long-established precedent and seem both reasonable and fair. Now, at the 2.5 hours that were set aside for this argument, there was extensive discussion about the cases and what controls and what cases are still relevant as the law of Florida. Now, these cases were 1985 decisions by the Supreme Court. Cases that came before 1985 are no longer the law of Florida. The Supreme Court does not spend its time telling the other districts that it has overruled itself. It simply adhered to a long-standing, 100-year-old case that said there would be a requirement of special injury. So the plaintiffs have attempted to allege special injury. They argue two basic special injuries. One, increased future traffic in the city of Miami. Number two, their fear of a future rise in sea level. Those are the two allegations of standing. But there's a disconnect between the plaintiff's challenges that are present here and the injury that they suggest. Because there's nothing related to sea level rise or increased traffic, which they argue will be impacted by their suggestion underlying that the city will not receive fair market value for the use of its property, or that the city erred in allowing the construction project to continue through an alleged phased development. Neither one of those possibilities is going to impact a rise in sea level or the increase in traffic. These lease terms to which they object have no logical relation to their alleged special injuries. People may fear traffic increases. In fact, anyone who drives in the streets of Dade County knows there's already an abundance of traffic. And sea level rise is a thought for everyone. But it's the fact that everybody has those concerns that means that these aren't special concerns for this group of citizens. In fact, in 2001, when the city voters approved this project by 68%, Mr. Herberts then launched into a series of challenges to the zoning of this project and raises some of the very same concerns in the 2001 challenge that he raises here. The courts in this courthouse, at various levels, including the three-judge court, ruled against it. And in any event, those zoning-related concerns are long since barred by the passage of time. I would like to show Your Honor a photograph. Mr. Grass was kind enough to give us a smaller version. Thank you.
I don't remember seeing photographs in the attachments in the 3 binders I received.
We did ask the court to take judicial notice of distances, and that's to which this
It's fine,
refers.
I don't have an issue with it, I just want to make sure that if there's a ruling and there's an appeal by one side or the other, that the appellate court has an idea of what I'm looking at. Do you plan on marking them, and is there any objection?
No objection.
Okay, so they'll be admitted. I guess we don't have a clerk here today, but we'll call this one that you're showing me now the paper document Exhibit A, and I'll ask my clerk to mark it when he comes in.
On the board that I'm showing to the court, you can see the city of Miami, you can see MacArthur Causeway, and the project, which is under construction, is marked with a gold star. This is the Port of Miami. This is Government Cut. These are the Venetian Islands. The nearest plaintiffs to the site live in a building here and here. And they look south to see the gold star. Your Honor, they are not even on the MacArthur Causeway. They're indicating to you that they want to measure the distance as the crow flies. I'm unable to drive my car as the crow flies. Wish I could, save a lot of time. But to get to MacArthur Causeway, they have to exit the Venetian Causeway, come through the city, and then get onto the expressway, which would take them to MacArthur Causeway. Other plaintiffs live here, on the Miami Beach side. And to get to MacArthur Causeway, they have to come all the way through South Beach, get on the causeway, and come this way. Other plaintiffs live in Coconut Grove. To get to MacArthur Causeway, they have to go up US 1. So if they want to complain about traffic, they ought to complain about US 1's traffic. The point being, that all of the people in Dade County share the same concerns. And thus, there is no special injury announced or meant or alleged. We're now here before Your Honor on a motion to dismiss a third amended complaint. So we did a comparison between the second amended complaint and the third amended complaint, which is also found in your materials. And on that basis, we can say, in terms of standing, the two complaints are in all material respects identical. The Florida Supreme Court has even stated that a taxpayer whose tax burden will increase as a result of governmental action has no standing to challenge that action unless they have a special injury. Today, the plaintiffs are asking this court to essentially hold that where there is no increase in tax burden, there is standing even without a special injury. Or to put it another way, they're urging this court to adopt a lower standard than that which has already been adopted by the Supreme Court of Florida. To do so would be contrary to the principles of law that govern this state. Your Honor, these plaintiffs are just members of the public, some of whom have been suing to stop this project for 10 years. The majority of the citizens of Miami spoke long ago. This project is underway. It has survived its zoning challenges. The suggestion that is being made with regard to whatever decision was made by the city of Miami is too late and can't be brought by these individuals. So therefore, Your Honor, we would say for the same reason this court previously dismissed this complaint, based on a lack of standing, because the allegations of violations of the city charter are the same allegations that the Supreme Court specifically dealt with when it dealt with charter violations. The court should dismiss the claims in counts 1, 2, and 3. So when I suggested that the complaint is in all respects materially the same, factually that's correct. However, there's a new legal theory brought, the Citizens' Bill of Rights. The suggestion that plaintiffs have standing now because of an allegation that certain City of Miami officials made untrue statements at city commission meetings, or that a city commissioner made untrue statements, or that the city didn't know the full facts because the staff didn't give them the full story, are alleged to be violations of the Miami-Dade County's Citizens' Bill of Rights. Now, what does that state? No municipal official or employee shall knowingly furnish false information on any public matter, nor knowingly omit significant facts when giving requested information to members of the public. Your Honor, that doesn't even allude to an allegation or a suggestion that a city is liable in some fashion for a false statement or a failure to provide all the significant facts. The claims are against the city, not against any particular city officials who allegedly did some wrongdoing. And I would add that there's no allegation that anyone knowingly furnished false information or intended to mislead the public. And the core allegations here go to legal opinions expressed by assistant city attorneys, which are alleged to be wrong, therefore false, therefore misleading, therefore a violation of the Citizens' Bill of Rights. But more basically, Your Honor, plaintiffs here suggest that any time a citizen believes a public official at a public hearing has lied or failed to tell the whole story, the citizen then has standing to challenge any governmental decision of any governmental body in Dade County. This notwithstanding that that right is only then available in Dade County. The plaintiffs also suggest, in effect, that Dade County Commission gave this court jurisdiction to determine whether the actions taken by the city of Miami should be enjoined. Because they allege the city commission either heard something from its staff that wasn't true or didn't hear all the significant facts. Now, the third district has spoken on this generally, and they said, quote, "We are bound by the Supreme Court of Florida precedent to affirm the lower court's dismissal because the taxpayer lacks standing to pursue the claim. He asserts neither special injury nor a valid, direct constitutional challenge," unquote. And that's the Brennett versus City of Miami case at tab A3. And plaintiffs go on to say that the Dade County Charter was created under the authority of the Florida Constitution, which gave Dade County, Metro at the time, the right to have a home rule charter. And therefore, it's not just a charter violation, it's a constitutional violation. Aside from lacking any authority at this point, plaintiff's argument is clearly invalid under Fornes and Bull. Exactly like these plaintiffs, Fornes and Bull, which challenged the governmental action, they claim was in violation of a charter provision and therefore void. Your Honor, we suggest that the Citizens' Bill of Rights cannot and does not eliminate the Supreme Court's requirement for plaintiffs to establish standing to maintain the claims they purport to bring. Without the special injury, the claim cannot be, without a special injury, the claim cannot be maintained.
Concentrated Judge Green, sort of distracting how wonderful court was. Let's just wait till the gentleman passes the order. There's actually, you missed it because you're not facing where I'm facing, but there was a group of gentlemen on one of those lifts going past the window.
I was blessed with the opportunity to work in this courthouse for 5 years, so I know this building very well. When I left it in 1975, it was still old.
It's over now.
Your Honor, the principle that I've just suggested of the Citizens' Bill of Rights was understood very well by the county. And that's why they put in paragraph D. And paragraph D says, quote, "All provisions of this article shall be construed to be supplementary to and not in conflict with the general laws of Florida," unquote. So to eradicate any possibility that the Dade County Commission, when it passed the Citizens' Bill of Rights, intended to create a nightmare scenario where any citizen who wants to allege that any statement made by any public official at any public hearing creates jurisdiction to challenge the decision that the city made is laid to rest by a view of the construction called for in the Citizens' Bill of Rights itself. Finally, Your Honor, there's one other argument made, and that is they want this court to find that Flagstone's agreement with the city is terminated due to an alleged default by Flagstone. They argue the agreement between the city is in default, and yet there's no allegation that the city has declared a default, or even thinks there might be a default. But the law of Florida is also clear that only a party to an agreement has a right to declare a default in that agreement. Non-parties have no such right, and we've cited to another third district case, State v. Walker at tab 9C, where John Fletcher in the note, Judge Fletcher in the note denying rehearing, said, by the way, only a party to an agreement. Suggestion, no allegation, that there's anything in this lease agreement that says that anybody is a third-party beneficiary. The case law is clear. A member of the public is not a third-party beneficiary of a public contract. And we cited several cases, Besch versus City of Maitland and Haynes versus Department of Lottery, C1 and C4. It's a generally accepted principle of law. Your Honor, the allegations that are being made, the new allegations that have just surfaced, do not go to standing at all. What you heard Mr. Dubin say is an argument on the merits, whether there was, in fact, a violation. That issue would only arise if the court finds that plaintiffs have standing. And in the absence of standing, that issue is not relevant to this motion, these motions. The court should dismiss count 5. Also, for lack of standing, make the argument, both because they're not beneficiaries of this contract, nor parties to it. Therefore, in sum, we ask the court to dismiss again this amended complaint, and note that they were invited after the last such hearing to take that issue to the Court of Appeal if they believe that the law in Florida is not as it appears in the case law that we cited. Thank you.
Your Honor, Sam Duffett for the plaintiffs. To start, I do object to this aerial because I believe the location of the flagstone development is not properly marked here. I'll discuss it with the other, I didn't really, that's why I wanted to check with my clients over there. I
It's already
believe,
been admitted in, but I did have the arguments that were in the pleadings on the
I'd like to, the record says that it's not properly placed, right? And then the way it's misplaced shows it to be further away from my client's residences than it in actuality is. So it's much closer to the MacArthur Causeway. It abuts the MacArthur Causeway. This basically shows it where the Children's Museum is. So it's just not an accurate depiction. But to be very clear, Your Honor, this is not 2004, and we are not challenging the zoning of this project. The only reason anything prior to 2004 is even alleged to refer to a complaint is that when the project was first authorized in 2001, it was done pursuant to the Miami City Charter sections 29A, 29B, and 29C. They required that the project be authorized by an RFP through competitive bidding, that there be a referendum, and it prohibits the commission from approving a lease of public land for less than fair market value. Those conditions were met in 2001. This complaint is about what happened in 2010 when the developer couldn't get the project going, and the city made a number of concessions that relieved the developer of what the developer put in the RFP response, what the city put on the referendum ballot land, and what they all agreed would be that the developer would always pay fair market value. And those violations render the actions void. And the voidness issue is something that has been the principle of Florida law for a century. In the Fornes case and the Bull case cited by the defendants, doesn't say a word about voidness. Those are taxpayer spending cases. This is not a taxpayer spending case. My clients are suing the city because of a comprehensive, widespread pattern of corruption. The city has violated public records laws to hide what it was doing from the public, violated fundamental requirements of the city charter. That's the basic governing document between the city and its people about how public land can be conveyed. That's people's legacy, people's progeny. And masking the impacts that it will have on the people who are going to be substantially affected, which do include my clients, which I'll get to. So we don't question the principle of the Florence case, of the Bull case. They addressed a very narrow point, which is, and they were both on certified questions from the lower courts. And the debate that had been going on for 50 or 60 years was, if you're a taxpayer and you're challenging a tax or an expenditure by a local government, is it enough to allege that your taxes are going up? And some courts had said yes, and some courts had said no. And the lower courts there said, they read the previous precedents to say, all you need to do is allege that your taxes are going up, and that's sufficient to give you standing to challenge a government expenditure or a tax that you believe is illegal. And that's all those cases say. They do not address, they don't even mention the word voidness. It's just completely irrelevant to the century of law that we are relying upon, going through the Anderson case, the Gladstein case, which is in the third DCA. It says where a city violates, where a contract entered into by the city deviates from the competitive bidding provisions that it issued to the public for purposes of a public project. And remember, Judge, this is not the people against the developer. This is public waterfront land on Mawson Island. This is land given by the state of Florida to the city for public purposes, which the city went to Tallahassee to get that condition relieved. But it's public land, and it's governed by that charter, and it belongs to the people of the city of Miami. And they have a right, as Dr. Gladstein and Ms. Turkel, who's here today, did in 1978 and 79, to go to, when this city was going to try to put an amusement park on Watson Island, to say, this contract deviates from what was issued as an RFP. And the circuit court gave summary judgment to the city, and on appeal, the third district said, a violation of the competitive bidding requirement, that the deviation of the competitive bidding requirement renders this contract void. And it reversed summary judgment and terminated the agreement. And that was based upon a series of other decisions which are not overruled by Florence and are not overruled by Bull, because as I pointed out in my supplemental submission the other day, the Supreme Court does not overrule cases sub silentio. So the voidness argument not only applies to violations of the competitive bidding requirements of the city charter, as it did in Gladstein and several other cases we cited, you also have an election law violation here. The referendum said the project would be built all at once, and that there would be a guarantee of $2 million a year. When the city commission in 2010, to let the developer off the mat, said you can build this in phases, they relieved the developer of the obligation to build it all at once and to pay $2 million a year, because the $2 million only kicks in when the project is finished. So there are three cases directly on point. Bryan, 1951 Supreme Court case. Ratner, 1971 third DCA case. And City of Hialeah versus Delgado, where citizens challenged the ballot language because it did not follow the city charter requirements for what had to be on the ballot. And in the Bryan case, the Supreme Court said the argument that a special injury required does not apply here because it's void for its violation of the charter. It's void. And in the Ratner case, the City of Miami Beach charter said that to give away public land, you had to have a referendum. And the referendum said, do you, the voters, support giving land to the Public Housing Authority for public housing? The public said yes. The city gave the land directly to the developer. The third DCA said that renders it void because it violated the terms of the referendum. And the appellant, who was Judge Crystal, by the way, didn't allege special injury. He did not want the city to be corrupted by simply willy-nilly violating its charter in the process of giving away public land. And the third DCA said it's void, and it reversed it. And in 2007, the third district again in Hialeah versus Delgado, that was a suit to enjoin a ballot that was misleading. And the city of Hialeah argued this guy has to have a special injury and he doesn't allege it. And Judge Cope said, the city is mistaking the taxpayer standing doctrine of forms, which only applies to taxpayer suits, with this election law violation because the charter was being amended. And the charter has a truth, there's a truth requirement there. So on an election case, which we have in this case, voidness allowed, anybody can sue when the referendum is violated. Now we have a third reason why it's void. And this is in the Supreme Court case of Menard, and the third district cases of, say, Brickell Ave, and a number of other cases we've cited in our memo, Your Honor, where if the city deviates from a procedural requirement of its laws and its code, the action is void and it can be challenged by anybody. And it's procedurally void, and no special injury is required. That's the Supreme Court's decision. That's what the third district in Menard has said. The fifth district in Bula, 1991, again, just to show you that this has nothing to do with forms or bull. This is again where the procedural requirements were not met. This is not merely a procedural notice problem. This case involves a jurisdictional issue and fundamental constitutional rights. The city had no authority to enact the ordinance without complying with the statutorily mandated notice and public hearings requirements. It is as though the ordinance does not exist. Now, why does that apply here? Because the City of Miami Charter 29B prohibits the City Commission from favorably considering a lease of public land for less than fair market value. Fair market value was $2 million in 2002 when the project was first made. And there were appraisals that said so. But in 2010, when they renegotiated everything, the city was different. But the RFP requirements still said that they had to pay fair market value. The charter still said they had to pay fair market value. The city in 2010, 2011, 2012, 2013, and 2014 favorably considered that lease of public land without charging fair market value. And in 2013 and 2014, they had appraisals in their possession that showed that the value had gone from $2 million to over $7 million. Appraisals which we only became aware of because Mr. Herbert sued the city in 2013 and got that after the city had re-upped the agreement at $2 million. And we had to sue the city again in 2014. And when we sued him in 2014, in Judge Traywick's case, one of the documents that they had been withholding between May 5th and August 20th was an email from the appraiser to Henry Torrey, the director of public facilities, which had a memorandum comparing fair market value in 2002, fair market value in 2014, and it said it was $2 million, it was $1.89 million in 2002, it's $7.2 million in 2014. And even though my clients appeared before that city commission and said, we think you're violating the city charter by not having a new appraisal here, we heard there was a new appraisal, what does it say? The city said nothing about it, and suppressed that memo until Herbert sued him and Judge Traywick ordered it to be reduced. But on May 8th, they favorably considered this lease again for $2 million, notwithstanding the fact that they knew darn well that fair market value was $7.2 million. Now remember, this is not about taxes going up or expenditures. This is a fundamental corruption of the basic terms on which the city is allowed to dispose of its public property. And it renders it void. The city was not allowed to favorably consider that lease of public land for less than fair market value, and it did. Now, I don't want to belabor this point because Judge Ige ruled against us on this point. I believe he was mistaken, but I promise you this is not an argument on rehearing. You have every authority, Your Honor, to revisit that issue. His decision is not final, and the Deemer case, which I've cited, says that you have every right to, just like Judge Ige would have the right to change his mind because it's non-final, you have the right to hold that special injury is not required. But let me move to the special injury because the fact is my clients have alleged special injury. They've alleged it in paragraphs 8, 9, 11, 13, and I can read it. I would like to read it, Your Honor. Sorry. plaintiffs Hurwitz, Craver, Shapiro, and Lynn live at 801 North Venetian Drive and 1000 Venetian, the two places marked there, directly across a narrow body of water from the Watson Island project that's being challenged here. They, along with their neighbors, live closer to the Flagstone project than any other city or Miami residents and will be directly harmed by the increased traffic, impairments to public safety, short and long-term negative environmental impacts, subsidies to developer, loss of open public space, lost or reduced property values, and other impacts the project will cause. The increased traffic from the Flagstone project on the MacArthur Causeway will not only increase traffic for Hurwitz, Wynn, Craver, and Shapiro during regular use, it will exacerbate traffic in and around their neighborhood and on the Venetian Causeway because, in their experience, when the traffic builds up on the MacArthur Causeway, it causes massive increases in the traffic on Venetian Causeway from drivers diverting their route to the Venetian Causeway. In addition, the value of Hurwitz's, Wynn's, Shapiro's, and Craver's investment will be reduced or will increase at a diminished rate based upon the several negative impacts of the project. Now, it says, given plaintiffs' proximity and direct use on or near Watson Island, they will be forced to bear a disproportionate price for the city of Miami's illegal actions and suffer substantial and immediate injuries, greater in kind than the injuries that will be suffered by the general public. And in the case of Ms. Turkel and Mr. Pepper, they live on the west side, and they allege, in addition to what the other four did, in their experience, build up on MacArthur will exacerbate traffic in and around their neighborhood because when traffic builds up on the MacArthur, it causes massive increases in the traffic on Alton Road and West Avenue and Miami Beach, as well as on the Venetian Causeway, and that their property values will be impaired by this. Now, they have alleged special injury. In the Fornes case and the Bull case, they did not allege special injury. They only alleged that their taxes would be going up. That was the sole injury that they alleged. And under Payne versus the City of Miami, Your Honor, these allegations are sacrosanct. They must be regarded as true. In Payne, determining whether to dismiss a complaint for lack of standing, we must confine our review to the four corners of the complaint, draw all inferences in favor of the pleader, and accept all well-pled allegations in the complaint as true. Now, they've alleged special injury. Now, last time we were here, the other side tried to argue that the traffic isn't a special injury. You notice that Mr. Diamond left out two of the most important special injury allegations that were actually alleged: reduced property values as well as diminished traffic safety. Now, the Rinker case is a 3rd District case, Your Honor, in which the Rinker Cement Corporation challenged a zoning grant of residential zoning next to its property because it alleged that when those people, moved there, they'd complain about blasting and would go and get their permit revoked. The trial court, and that the value of their property would be diminished because of that. The trial court said that the court could not hear evidence supporting Rinker's argument that the property value would be lost. And the 3rd District reversed. Third District reversed. The party challenge, now now, let me just say this. What is a special injury? We contend that we don't have to allege special injury because these are voidness cases on all 4 categories. The 4th category, by the way, is that there's the procedural fair market value problem that the Commission wasn't allowed to take it up, and there's the substantive fair market value problem, which is that the city is not allowed to charge less than fair market value. And in the Gunderson case in the 2nd TCA, the court there said that where you don't get fair market value as required by your charter, it's void. So you got 4 bases on which that's void. And in all these voidness cases, sometimes special injury is addressed and rejected, and that's never been reversed by the Supreme Court, and they don't reverse themselves so much. Or the cases went forward without any discussion of special injury because it's void. And nothing in the Florence or Bull case overrules the doctrine that void actions must be overturned by the court because, as they said in the Bulla case, they're void ab initio. It's as if they never existed. So talking about a special injury in this context is somewhat unusual, because it's never been the law with regard to plaintiffs who are seeking to enforce the charter, not because their taxes are low enough, but because what was done was poor. So now we have to draw from analogous areas like zoning and land use, where there is a body of law on special interest. And in that body of law, in the Rinker case, the Rinker alleged that his property values would go down. The third district said it was error to dismiss the case without giving Rinker the chance to bring in expert testimony to prove it. Since the trial court improperly prevented Rinker from presenting expert testimony concerning the effect the ordinance had on the value of its interests, its decision that Rinker's legally recognizable property interests were not adversely affected, and therefore that Rinker lacked standing, was erroneous. So that's the property value issue. In Gardner, Your Honor, another third district case, the plaintiffs lived, it was the Grove Island being built, the plaintiffs lived on the land side. They had standing to challenge what was happening on that spit of land because it was directly across a narrow body of water, and they alleged their views would be compromised and the receding floodwaters would be detrimental to them and cause them an increased risk of storm flood. The third district held that was a sufficient special injury to give those people standing. That mirrors my client's allegations as well. And the most important case is Carlos Estates, where this was another zoning challenge, and the neighbors said, this is going to impact negatively on our traffic safety, on the safety of our neighborhoods because of the increased traffic. And the third district said that was a sufficient special injury. And here's what was really important about that case, because they're going to cite cases from other districts with a different conclusion. The third district in Carlos Estates said that the fact that this is an injury that will be shared by the plaintiff's neighbors doesn't mean it's not a special injury sufficient to confer standing. It's still different from what the rest of the community is going to suffer. And we've certainly alleged, and have, that allegation is sacrosanct, as I said, but it's also verifiable, that this is going to happen to them and their neighbors. My clients aren't the only ones who are going to be injured that way, but to say that the people living in Hialeah are going to be impacted the same because they might have traffic, which is what they argued in their papers, is nonsense. Now, the other problem with their special injury argument is, if my clients don't have special injury, who does? Well, they previously said that you had to live on Watson, you had to be on Watson Island to have a special injury. Those are the only people who were sufficiently affected. Well, who's on Watson Island? The Children's Museum and Jungle Island and other lessees of the city. Well, if you're a lessee of the city and you get a subsidy from the city, you're not going to challenge their illegal disposition of part of that island. We know that. And it's ridiculous to make the argument they're the people who should be brought. This is still public land. The fact that the Children's Museum is leasing from the city or Jungle Island is leasing from the city doesn't mean that they're the only ones with special injury. Our clients my clients have alleged that they will be specially injured. And the argument that only other people on Watson Island can, since there are no private other people who aren't connected somehow to the city, is ludicrous. And then their other argument is that the Attorney General of the state of Florida, that's who's going to come in and enforce the city charter. That's Flagstone's argument, and that's basically the city's argument too. Some public official is the one who has standing. Well, Flagstone cites two cases involving the Attorney General. One where he was part of a group that sought to overturn the Parole Commission's reduction in sentence of a serial criminal who had violated the Land Sales Act, and the Parole Commission produced his sentence. And the Florida Attorney General was given the authority on behalf of the people of Florida to intervene in that case and challenge that. Of course, that's what we expect the Attorney General to do. That has nothing to do with enforcing the city charter of the city of Miami. And the other case was a case where the Supreme Court said that the Attorney General had the right to intervene on behalf of the people of Florida before the Public Service Commission when it was going to raise rates, because, he represented the state, because the state pays insurance rates, and the citizens of the state, that's the same as the state, because the state and the citizens are all the same. That's a logic. That was before you had the public, counsel for the Public Service Commission. They do not cite a case where the Attorney General of the state of Florida has gone into a court to challenge a local government's violation of its charter. So the upshot of what the city and Flagstone want this court to hold is that no one has standing to challenge these void acts by the city with regard to the disposition of their public land. Even though it's going to hurt certain people who are going to be uniquely impacted, and even though the city has gone out of its way to hide what those impacts are. And I would go back to Rinker, by the way, Your Honor. I think it's the height of arrogance for the city to say they can't prove that the traffic is going to hurt them, and yet this complaint alleges, and the documents show, that the city of Miami has studiously avoided doing anything that would measure the current actual impact of the traffic on all of these areas in the year 2014. Well, a lot's changed in downtown Miami and Miami Beach in 2014 from 2004 when the other traffic study was done. And yet the city didn't do a current traffic study. The study that was done by the developer that Ms. Bravo vouched for, which we put in the deposition, was something she had never seen before, and it only measured one little spot. It doesn't measure the impacts broadly, and that's why the city of Miami Beach has resolved that it's going to do a traffic study of its own. But to dismiss on standing on the ground that traffic allegations are not sufficient when the city is suppressing and coaching the developer on how to submit their applications so that they wouldn't have to go through public hearings or have a new traffic study, which is attached to our response, Your Honor, is, that's entirely unfair, but it's consistent with the MO that the city is above the law, that it's above the challenge, and that neither the citizens nor the courts have the ability to step in and say, you're doing the wrong thing. Now, so we've alleged standing. Those allegations are sacrosanct. They have to be taken as true. The Bull and the Thorns case did not have allegations of special injury. My clients have alleged it. And under Rinker, it would be error to dismiss it without giving my clients the chance to prove it. Now, on count 4 of the Citizens' Bill of Rights, the Miami-Dade County Charter has a mandate for truth in government. And it says that if any municipal official intentionally misrepresents a fact or withholds material information, that an individual has a right to challenge that in the general equity jurisdiction of the circuit court. Now, if the City of Miami Charter had a provision that said any citizen who believes that the charter has been violated can go to court, then they would have the right to go to court because the governing body would be authorizing a suit. There is a very specific private right of action in truth in government provision of the Miami-Dade County Charter, and it's clear. So the argument that, notwithstanding the grant of a specific private right of action, that there's some overlay of a special injury on top of that is nonsense. This is what legislatures can do when they have laws that they are advancing, like the Charter, like the Citizens' Bill of Rights, and it mandates that you can't withhold or provide material misinformation, so that we have the right to go to court. But to say that we should only be able to go to court against the individual, we all know that cities can only act through their agents. If one person receives the memo from the appraiser that says fair market value is really $7.2 million and either gives it to the commission and they don't disclose it, or doesn't give it to the commission, or gives it to his boss, I mean, they're all covering up information, but it's the city's responsibility because they're the ones harming the public by not providing that information. And the argument that this is preempted by state law is also, they've argued that the Florida Public Records Law, Chapter 119, preempts the truth in government provision of the Dade County Charter. Well, the case they cite is Canella versus the Tribune Company. And in that case, the newspaper asked for the public records pertaining to an investigation of a police officer. The city of Tampa had an internal policy that they had 7 days to notify the individual about a request for their records, personnel records. The Supreme Court said, you can't do that. I mean, the statute governs the disposition of public records, and if it's, the cities don't have the right to narrow what the Florida statute requires. And it said those documents have to be available immediately. We're not asking for public records in this case. We're enforcing Chapter 119 in a case that's now before Judge Raboul. It's the documents that have been produced on June 2nd. And, the city takes the position, which is not supported, that the special injury requirement is a requirement affecting all government actions. It's not. It goes to taxpayer standing. because the taxpayers paying. But when it comes to count 5, where the plaintiffs are saying, we're going to be hurt by this project, which should be terminated because the city did not enforce that June 2nd start date, and everybody knows they didn't start June 2nd, now the city has a new argument that, no, you got to be a third-party beneficiary. Well, if the special injury, is the test, my clients have special injury because they're the ones who are going to be damaged by the fact that that project wasn't terminated. But this is not just the enforcement of a legal document, Your Honor. That's what I want to emphasize. The June 2nd start date was a centerpiece of the entire debate that went on May 8th before the City Commission about whether or not the city should allow it to go forward and give the developer the chance to start June 2nd, or whether they should say, enough is enough, we've seen enough, the developer hasn't been able to get started, and we're going to say no, which is what 2 of the commissioners said they would have voted had they not been informed that it was a violation of the contract. So this goes to the central issue of the corruption of the process. If the people within the city administration, who are the ones lying to the public about what the consequences of not voting yes are the same ones who are charged with allowing the developer to not start by June 2nd and say they started, well, that's, where is the public's protection there? So my clients are going to be especially damaged by the fact that this project hasn't, that the project is being allowed to go forward, notwithstanding the fact that it violates Charter Section 29A, Charter Section 29B, Charter Section 29C, that was brought about through misrepresentations and intentional misrepresentations and omissions, and that the city is allowing the developer to continue even though they did not meet the June 2nd start date, which of course is why I've raised this other issue today about the permit that sort of came out of nowhere, that's a smoking gun showing that the city is engaging in all kinds of conduct that, dishonorable conduct to conceal what's really going on in this project. And that's what the courts are here for. If my clients don't have standing to raise these issues and at least allow this court to examine the actions of the city and decide whether or not it has complied, not in 2004, but in 2010, 2014, then we have no accountability in local government at all. And that's why we respectfully request the court to deny the defendant's motions to dismiss and order them to answer within 10 days. Thank you.
If it's okay with the court, Mr. Bass would like to address the zoning issue for a few minutes, and then I'd like to close up the rebuttal.
I'm here, just, come on.
Good afternoon, Your Honor. Nice to see you, Jeffrey Bass, Shubin and Bass, on behalf of Flagstone. Just a very small but important point. Reference was made to the Payne decision by Mr. Dubbin for the proposition that the nature of his allegations sufficiently allege standing for this challenge. It's vitally important to read the cases for the context in which they were decided. Payne was brought pursuant to Florida Statute 163.3215. That's from Florida's Growth Management Act. That act was adopted to create and authorize a very specific cause of action, not relevant here. 163.3215 says one may challenge a development for inconsistency with an adopted comprehensive plan if you make certain types of allegations. And the court was quite clear to say, the third district, this remedy was created to change the common law of standing that generally prevails outside of this narrowly created express legislative remedial action, which does require the showing of a legally sufficient special injury in order to proceed. So pain cannot be read outside of the statutory context in which it was decided, and it punctuates the point here that the challenge is about a development project that was approved by the voters. And Mr. Dubin said, and I just have to make clear because I was there and handled this aspect of the case, that his words, this was brought about by misrepresentations by the city. To the precise contrary, the electors of the city of Miami had a choice about Watson Island and its commercial development. That choice was expressly set forth on the ballot. It was not a general choice. It was a very specific choice. It was a choice as to whether or not, and this is from the allegations, whether or not a mega yacht marina, fish market, hotel with timeshare units, a maritime museum, public gardens, cultural facilities, restaurants, and the like, should be developed by Flagstone on Watson Island. That question was asked of the electors, and it was answered in the affirmative in 2001. The traffic impacts and environmental impacts of that decision were litigated and resolved. This case now boils down to a disagreement with certain elected officials about money, lease terms, and whether or not those lease terms are sufficient, in the opinion of the plaintiffs, they're not. That is a classic taxpayer disagreement with an action by elected officials, and the remedy for the types of allegations that have been presented here, respectfully, is at the ballot box. But it is not through a litigation of this variety challenging this project this way at this time. I'll go back to the city. Thank you.
Can I just clarify one point, Your Honor, on Payne? I only saw
Case, they're challenging the city's financial transaction, the financial decisions. It brings this case directly within the scope of the special injury rule, and therefore a special injury must be alleged. They failed to do that. Their main argument that they've been impacted is by traffic. We cited City of Sarasota versus Wyndham, and in that case, which is it's persuasive on this issue, the City of Sarasota installed speed humps on a public roadway, and the citizens, a few plaintiffs, they sued the city saying, you can't do that, that's in violation of Florida statute. Well, the district court on appeal held that these plaintiffs did not have standing because they didn't have a special injury. Traffic affects everyone. You're no different than the general public. You don't have standing. Another argument that Mr. Dubin raised is that a charter violation is a special injury. That was raised and rejected in Fornes and in Bull on two separate occasions by the Florida Supreme Court. Both of those cases involved allegations that there were violations of the competitive bidding procedures in charter. That's the exact same argument that the plaintiffs are alleging here, is that the city has violated its charter and the procurement and competitive bidding process. So the argument that they're raising and I guess the exception that they're trying to create now has already been rejected. The Supreme Court has refused to expand the exceptions to the special injury rule beyond what they've already done. And so it's improper for the plaintiffs to now come into this court and try to expand the type of exceptions that the court has already recognized. They cited several cases. The main case that they hang their hat on is Gladstein. And they cite Gladstein for this overreaching proposition that citizens have standing to challenge any illegal government action. And that's not true. Gladstein says no such thing. Gladstein does not discuss standing at all. And the Godheim case, which I referenced earlier, analyzed Gladstein. And they said, quote, the case of Gladstein versus City of Miami can only be explained if it be assumed that the standing question was never raised. And that's apparent from a plain reading of that opinion. There's no indication that the city challenged standing or raised standing, and the third district certainly did not address it. The other cases that counsel cited are distinguishable because they either don't allege standing, they predate forms, or their zoning or constitutional challenges, which it's well recognized that those are exceptions, but those exceptions don't apply here. They now try to create another ground saying that they have a special injury or that they have standing based on a challenge to the ballot, which that's not within the four corners of the complaint. That was raised for the first time in their response to our motion to dismiss, so that's not an issue. Judge Ide, in his order, granted leave on two specific issues, which counsel, he didn't seek rehearing or reconsideration to try to allege additional grounds. And those two grounds were special injury and a constitutional challenge, not voting, not zoning, not anything else. So he is limited to that, and so he is precluded at this point from trying to raise voting or a challenge to a ballot as an additional ground for standing. One other point that I want to address is this notion that if the court adopts the city and Flagstone's position that no citizen can challenge alleged government illegal action, that's just not true. The cases going back to Rickman, which started the whole special injury rule, has stated that the proper person to bring a suit of that kind is the appropriate public representative. Sometimes it may be the Attorney General. In other cases, it could be somebody else. For instance, going back to the Windham case, recalling that that is the case where the city installed speed humps to try to control traffic. The court said not only do you not have standing because you don't allege a special injury, but it says the plaintiffs have tested the city's authority to install a specific type of device. The power to challenge that installation, however, rests not with the plaintiffs but with the Department of Transportation. So that is an appropriate public representative in that case that is recognized to bring suit on behalf of the citizen. And so case law, not the city, it's the courts of appeals and the Florida Supreme Court have recognized that this is the proper way for a citizen to challenge illegal government action. In addition to alleging a special injury or constitutional challenge, if they want to go through the court system, that is the way to do it. Have the appropriate public representative bring suit on their behalf, and then the ultimate remedy for any citizen is at the polls. If they disagree with a decision or action that is taken by the government, the ultimate remedy is at the polls where they can exercise their power in that way. They may not agree, they may not like that, but the 3rd District in Paul versus Blake, which was approved in Florence, has stated the policy reason for that, which is that if citizens are allowed to bring these types of suits, the courts will be inundated with suits alleging all different types of government inaction or illegal activity, and government function will essentially grind to a halt. The government would be fighting off lawsuits, defending lawsuits, rather than providing services to the citizens. And so it's a policy decision that the courts have made. The Florida Supreme Court and the 3rd District, which are binding on the court, have made these policy decisions, and that's what justifies the special injury rule. These aren't random and arbitrary rules that are in place to prevent the citizen from having their day in court. They're based on sound policy, and unless they have an exception or they have something that's different from that of the general public, they're not allowed to bring government challenges in that sense. I just want to close with 2 final points with regards to counts 4 and 5. The city adopts Flagstone's arguments with regard to standing on those counts. I'd also just like to add that before the court even gets to standing on those counts, they're not properly before this court. The court, Judge Ide in his order, specifically said that they had leave to amend in order to allege standing, not to add additional counts. And under Rules of Civil Procedure 1.190, in order to add additional counts in an amended complaint, you need either leave of court or written consent of the parties. They have neither in this case. They decided to unilaterally add these counts without court permission. And the case that we cited from the 3rd District, which is Diaz versus Capital Corporation, in a very analogous situation, dismissed the complaint or affirmed the dismissal of an amended complaint where it was amended to add additional defendants without leave of court or written consent. And it's the city's position that that is instructive on this case where they've added additional counts without leave or written consent. And as Mr. Diamond stated earlier, the county Bill of Rights, Citizens Bill of Rights, does not apply to municipalities on its face. It doesn't apply. Your Honor has heard, has read the motions, has heard ample arguments here today. But what is apparent from both is that this case is controlled by thorns and both. This issue that the plaintiffs have raised has already been raised and decided, and it was decided well over 30 years ago. And it is that precedent that this court should look to in deciding the issue of the lack of standing on the plaintiff's part. Therefore, because they have failed to establish a special injury or a constitutional challenge, they haven't proven standing, and we're asking that the court dismiss the third amendment complaint with prejudice.
Your Honor, I'm not going to go through everything I disagree with, but Mr. Andrews is patently incorrect. The third amendment complaint, count 2, goes directly at the referendum issue, the ballot issue. That's paragraphs 70 through 75, as well as paragraphs 25 through 30. The deviation from the referendum is a central part of this case. And of course, that has nothing to do with Thorns or the Bull case, Your Honor. With respect to the amendment, the footnote in my memorandum addresses that it would, not only do we not violate Judge Ike's ruling, it would have been error for him to try to limit an amendment when we can state a cause of action. And if counts 4 and 5 state a cause of action, I mean, that's the law. I mean, the amendments, cases cannot be, plaintiffs cannot be limited as long as there's a possibility that the facts could support a cause of action. And counts 4 and 5 are well within what has been going on here. And there was nothing in his order that limited us, nor could there have been. And last thing, count 4, the Miami-Dade County Bill of Rights says, the city said it doesn't apply to the city of Miami. It says, no county or municipal official or employee shall knowingly furnish false information on any public matter, nor knowingly omit significant facts when giving requested information to members of the public. The city of Miami is a municipality within Miami-Dade County, so it undoubtedly applies to municipality. That's Article A2 of the Miami-Dade County Citizens Bill of Rights, which we allege in paragraph 85 of our third amendment complaint.
All right.